Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're covering how a New Jersey federal judge upheld their new magazine ban. SB Tactical, the originator of the pistol stabilizing brace, set the bar for innovation and product development in the PDW pistol category. From the insanely popular SB-M4 to the adjustable SB-A3 and even kits for pump-action firearms, SB Tactical braces are available for a wide variety of firearm platforms in fixed, adjustable, and side-folding models. To get 15% off your legally transported and carried pistol braces, use the code TGC15 over at sb-tactical.com. In early June of this year, New Jersey passed a number of new laws, including a ban on large capacity magazines, or LCMs. Under the new law, New Jerseyans could have magazines that held up to 10 rounds, a reduction from the previously allowed 15-round magazines. The Association of New Jersey Rifle and Pistol Clubs, or ANJRPC, along with several individuals, sued the Attorney General of New Jersey, the State Police Superintendent, and two others, claiming that the new law violated New Jersey citizens' constitutional right to keep and bear arms and constituted an unlawful taking of property. The plaintiffs sought a preliminary injunction to prevent the law from taking effect, which was denied by the district court. In its analysis, the court began by noting the increase in mass shootings in the United States, finding that there's anecdotal evidence that lives have been saved because the shooter had to reload. It then proceeded to examine the history and tradition of LCM restrictions. The court noted that for the majority of the 20th century, the most commonly owned handgun was a revolver, which was limited to 6 rounds of ammunition. But it also found between 1980 and 1991, semi-automatic pistols became the dominant handgun, leading to Hawaii and New Jersey restricting magazine capacity to 10 and 15 rounds respectively. Since then, 9 states have enacted restrictions on magazine capacity. The court then turned to a couple of expert witnesses, but we're not going to dive into the weeds with their testimony because the court found that it was of little help in its analysis. At least 2 of those witnesses relied on questionable data and conflicting studies, which led the court to determine that while they were credible witnesses, their testimony failed to convey the effect the law would have on reducing mass shootings in New Jersey, or to what extent the law would impede gun owners from defending themselves. In order to grant a preliminary injunction that is being sought here, the party seeking it has to show 4 factors. Those factors are 1, that they have a reasonable probability of success on the merits, 2, irreparable injury would occur if the injunction was not granted, 3, the granting of the injunction would not result in a greater harm to the party that wasn't seeking it, and 4, the public interest weighs in favor of granting that injunction. In support of the first element, the plaintiffs allege that the ban infringes on their Second Amendment rights, that it violated the Equal Protection Clause of the 14th Amendment, and that the law is an unconstitutional takings. The court applied a 2-part test to the Second Amendment claim, which requires a determination of whether the law imposes a burden on conduct falling under the Second Amendment, and then an evaluation under a means and scrutiny test. It first determined that the magazines are arms for the purposes of the Second Amendment, and as such, the law did burden conduct under it. In step 2 of the analysis, the government has the burden of showing that it had a substantial interest in the law and that there was a reasonable fit between that interest and the law so that the law did not burden more conduct than was reasonably necessary. The court dealt with the second prong of the test in short order. It found that the state had a substantial interest in protecting its citizens' safety and that the law placed a minimal burden on gun owners because it merely limited a capacity of a single magazine. A gun owner preparing to fire more than 10 rounds in self-defense can legally purchase multiple magazines and fill them with 10 bullets each. Yep, that's an actual quote.
What the
Learn how to reload! The court also noted the population density of the state and that the legislature determined that magazine capacity limits are necessary for public safety. As such, the court found against the plaintiffs on the Second Amendment claim. In relation to the equal protection claim, the court found that the plaintiffs were not treated differently from others in a similar situation. In particular, the analysis focused on retired and active police officers. The court found that because those individuals are required to undergo semi-annual training, face a potential threat from individuals they had previously arrested, and are expected to act in the public interest, they were not in a similar situation as the plaintiffs. Thus, the 14th Amendment claim was denied. Lastly, under the takings claim, the court found that because individuals could modify their magazines to comply with the new law, no takings had occurred. Because the court found that the plaintiffs were unable to show a likelihood of success on any of their claims, it didn't address the other elements required for a preliminary injunction. Now, remember, this decision is only in relation to the preliminary injunction. It's not a final decision from the court in relation to the challenge of the law itself. However, ANJRPC is not taking the court's order lying down. They appealed the decision to the Third Circuit and have requested an expedited appeal in order to have a final determination on the issue of the preliminary injunction before the law takes effect. So, it is possible for the Third Circuit to order an injunction which would temporarily prevent the law from going into effect. Now, I think this is an interesting case study to see how the Third Circuit will address certain issues. The district court is clearly differentiating current and former law enforcement from their fellow citizens. I'm also interested to see how the Third Circuit addresses that issue, as well as its position on the government showing a substantial interest in the magazine capacity issue. While this currently only affects New Jersey, if this case is ultimately appealed to the Third Circuit, the implications could be far greater and affect a broader group of individuals. That is, unless SCOTUS weighs in on the issue from another circuit before this makes it that far. I'm curious to know, what do you guys think of magazine capacity limits? Do you live in an area where they're already imposed? How does it affect you? If you don't, are you worried that this is going to happen to you? Post your thoughts down in the comments below. That's it for this episode. If you learned anything, make sure you like this video and share it around with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. Be sure to check out the Gun Collective podcast on iTunes, and as always, thanks for watching. Don't forget to get subscribed, and if you haven't already, nope, one more time. That's it for this episode. That's it for this episode. If you liked it, nope, one more time. I got it. I don't need it. I'm good. Links for this episode are provided by...
The shirts worn in today's video on the Gun Collective have been provided by PATRIOT Patch. Closed captions have also been brought to you by PATRIOT Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.